Thanks everybody for joining us today. My name's Adam White. I'm co-director of the Antonin Scalia Law School's Boyden Gray Center for the study of the administrative state. And it's a real pleasure to welcome you today for the first day of a two-day webinar series we're hosting on equity and the administrative state in conjunction with the Georgetown Journal of Law and Public Policy. And needless to say, in the last few years, there has been a flourishing debate over equity, social justice, and the rule of law in modern administration, both from the Supreme Court's recent decisions in the Harvard and University of North Carolina cases, and also in light of President Biden's executive orders on racial justice, including his Day 1 executive order titled Executive Order on Advancing Racial Equity and Support for Underserved Communities through the Federal Government. And then, of course, everything that's carried on through the agencies. It's a great time to stop and take stock of these developments and the broader themes of administrative and constitutional law. Tomorrow we'll take a look more broadly at equity and administrative law, but today, especially in light of the recent, as I said, orders and Supreme Court decisions, we wanted to look more specifically at racial classifications and democratic institutions. We're incredibly lucky to be joined by our speakers today. The first three are David Bernstein, a university professor of law and executive director of the George Mason University Antonin Scalia Law School's Liberty and Law Center. He's also the author recently of a book titled Classified: The Untold Story of Racial Classification in America. We're also joined by Jonathan Berry. He's managing partner of the law firm of Boyden Gray PLLC. And anytime I mention that firm, I probably have to make a disclaimer. No, the Gray Center is not related to the firm. Boyden Gray founded that law firm. He supported the Gray Center here over the years, but they are, in fact, two different institutions. But still, John, we're very glad for you to be here as well. I should add, before John joined the law firm of Boyden Gray, he served in senior levels at, among other things, the U.S. Department of Labor. We're also joined by Professor Joy Milligan, the Martha Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia School of Law. She also is a leading scholar on so many of these issues, and before all that, she practiced law at the NAACP's Legal Defense and Education Fund. And before I introduce our moderator, I just want to say the three that I just introduced have all written essays for a forthcoming symposium in the Georgetown Journal of Law and Public Policy alongside tomorrow's speakers. And so we're very grateful for the chance to preview their papers on today's webinar and the podcast. But their conversation will be moderated by Professor Renée Landers. She's professor of law at Suffolk University's Law School, where she's also the faculty director for the Health and Biomedical Law Concentration and their program for the Master of Science in Law on Life Sciences. Before all that, Renée served in senior levels of the Justice Department, the Department of Health and Human Services. And she also is the past chair of the ABA's Administrative Law Section, where I've had the pleasure of working with her and knowing her for many years. So, Renée, thank you so much for joining us. Thank you for leading the conversation. And now I'll happily join the rest of the audience.
Well, good afternoon, everyone. And thank you, Adam, so much for that very generous introduction for all of the panelists. And I'm especially grateful to know that a person like Adam has succeeded me after several years as the current chair of this section of Administrative Law and Regulatory Practice of the American Bar Association. And of course, I'm totally honest in saying that he's doing a much better job than I ever did in that role. But thank you, everyone, for joining us today and for the webinar and for if you're viewing this later on the podcast. We're really delighted to be able to present these three scholars to talk about their work. I will echo Adam's comments in the overall introduction that a lot of these issues about race and government have been especially top of mind as the litigation involving the Harvard and University of North Carolina cases and the challenges to their use of race in admissions policies by the Students for Fair Admission made those cases made their way through the courts, and then of course a lot of commentary on the Supreme Court's decision. And just this week, a couple of days ago, the Supreme Court denied cert in the case of the Coalition for TJ against the Fairfax County School Board, which had, raised a series of follow-on issues about the implications of the Students for Fair Admission cases. So this conversation, I think, is a conversation about the use of race in government programs will continue for quite a while. But of course, as some of the papers allude to, this conversation has been one that the country has been having since inception. And so it's very useful to have the insights of these three people who've thought about a couple of key issues. Our first speaker will be Joy Milligan, who Adam has already given a really powerful introduction for. And her paper is entitled The Counterfactual Administrative State, Beyond Equity, the Counterfactual Administrative State, which she will bring a lens of in examining the historical origins of where we are in terms of racial equity in a lot of social insurance and other programs in the country, and education particularly. And then next we will hear from David Bernstein, who will, his paper is entitled Racial Box Checking and the Administrative State, which I think echoes a lot of the themes in his recent book that Adam alluded to in the overall introduction. And then finally, our third speaker will be Jonathan Berry, who will talk about a couple of examples in the labor regulation context about the use of race in those kinds of programs. So I will say that we will allow, each speaker will speak about 10 minutes to present the main thrust of their ideas, and then we will have a period of time where the panelists can interact and respond to each other, react to each other's comments. I will perhaps ask a few questions, and then toward the end of the allotted time, we will turn to audience questions. So to the extent that people in the audience have questions, please do start sending them in as soon as the question occurs to you. All right, so Joy, I will turn it over to you now to start us off.
Great. Thank you, Renee. Thank you, Adam. I appreciate the chance to be here with all of you today. And so I'll just jump in. The topic of our panel is racial classifications in democratic institutions. As mentioned, my essay for the symposium is directed a little bit differently than David's and Jonathan's, which are in closer dialogue with one another. But I do think we all speak to the underlying theme and title of the panel, though I focus less on racial classification's role in the present. So I'm going to first sketch the outlines of my essay and then try to connect it to some of the ideas in David and Jonathan's work, which I think will also be able to flesh out some of those connections in discussion as well. So my essay is called Beyond Equity, and in it, rather than focusing simply on the current equity approaches in agencies, I actually tried to call for deeper thinking about how to render the administrative state more legitimate and responsive to democratic majorities, including especially parts of the population, like communities of color, who were long excluded from decisions about the nature and reach of the administrative state. One of the elements of this legitimacy deficit that I point to is based in the simple fact that many elements in the administrative state, agencies, programs, various bureaucracies are relatively old, and they were built out at a time when the United States was not functioning as a multiracial democracy. As we all know, Black Americans and other people, other minorities were denied a role in politics through disenfranchisement in the South and Southwest, even well after the end of slavery and the enactment of the 15th Amendment. Once Jim Crow took hold, most of those states really didn't function democratically again until after the Voting Rights Act of 1965 was enacted. So to me, our multiracial democracy is a relatively new development. And as a result of that history, Congress and other governing institutions weren't responsive to the full population. Many aspects of public policy and programs were seriously distorted by that democratic deficit in ways that specifically hurt people of color. A major portion of my past work has pointed to federal agencies' role in and reasons for participating in Jim Crow by funding and supporting segregated schools, job programs, higher ed, farm programs, programs, housing, all decisions that were rooted at both the agency and congressional and higher executive level, decisions that were rooted in those underlying undemocratic political realities. But for me, the lesson I'm drawn from that history is not that the federal administrative state is pernicious in itself, or even, as we may discuss more later, that racial classifications are pernicious in and of themselves. Rather, to me, it shows that agencies were built at specific points in time to respond to particular political actors and constituencies functioning in an undemocratic system that excluded others' voices. And so the tremendous, for example, racial wealth disparities that we know now are rooted partly in the fact that those egalitarian policies that grew out of the New Deal and out of that modern administrative state disproportionately benefited whites and created many forms of economic, human, and political capital in white families that have persisted over generations and were denied to others in ways that still impact us in the present. So part of my piece is just imagining what sort of administrative state might we have seen under a properly democratic regime? How might that affect how we think about the administrative state and its programs now? I assume as a starting point, and again, this is something we may differ on and want to discuss, but I assume that we have some interest in correcting and responding to present day inequality that grows out of that undemocratic and racially oppressive past. So as an example of these types of administrative structures and programs and policies that stem from that prior decision-making, undemocratic decision-making, I focus on the example of federal aid to education, the history of that long-running legislative proposal. It emerged first in Reconstruction, and it was backed and fought for decades without ever being implemented or adopted until the 1960s, in the same era that gave us the major civil rights statutes. And the context for driving these legislative attempts at securing broad federal aid to the states to support their education systems was a concern with really grave inequalities in the level at which states did and could support their public schools. Per pupil spending varied massively in 1880 and 1920 and 1936, just as it does now by state and locality and other factors, including obviously race. So there was also, along with that funding, there was a concern with the very disparate outcomes that we're seeing in terms of people's literacy and their productivity as a result of being in these differently funded schools, and the overall impact on the nation's well-being. Those concerns were most extreme in regards to the South throughout that time. The meager funding and high illiteracy rates in the South relative to the rest of the nation played a key role consistently in these legislative campaigns. And race obviously inflected and shaped those disparities that were much worse for African Americans, both at the start of these campaigns in the Reconstruction era because of the legacy of slavery, and then going forward due to the underfunding of segregated schools and lack thereof completely, and the failure to provide, high schools and higher education in many areas for Black Americans. So for Black Americans in the South, and more broadly for civil rights leaders at the national level, like the heads of the NAACP and other civil rights organizations, federal aid to education looked critical. And as part of that proposed legislation, they also backed a much stronger and more robust federal education department. This is part of an overall commitment, which we tend to forget about as a historical matter, on the part of Black leaders and civil rights groups to broad and generously redistributive social policy implemented at the level of the federal government. In the education context, these federal aid to education bills often looked very close to passage, excruciatingly close, but they ultimately failed until the 1960s for some complex political reasons when we look at it in a granular way. But the underlying reality had one constant within all of these periods: a sweeping disfranchisement and exclusion of Black and other minorities Americans' interests from the political process. That undemocratic regime also excluded the interests of poor whites and other underserved white populations who would have benefited greatly from a regime of egalitarian school funding. Finally, in 1965, we saw the enactment of the Elementary and Secondary Education Act, our first general federal aid law. And we didn't see a federal cabinet level Department of Education until 1980. So these are relatively new developments. My ultimate point is that if we root ourselves in a very deep understanding of our history, both the institutions and the policy landscape that we have are shaped by that undemocratic and racially exclusionary past. And that looking back to a counterfactual like this one helps us realize that the present reality, including the lack of, say, a commitment to equal school funding for every child, which is obviously a race-neutral general social policy goal, and support for that kind of policy from a strong federal education department, that the lack of those things are not necessary outcomes. They're not even necessarily democratically chosen ones, given the strong path dependence of our institutions, the ways in which choices made earlier in our political development become harder and harder to overcome over time. Even now, when formal democracy is mostly secured, we think. As for the connection between this history and the more modern history and debate over racial classifications that I think David and Jonathan will foreground, I would say for now simply that I do think we have to take account of that longer history when we grapple with the schemes and agency role that have been built out since mid-century and especially since the 1970s. I do see those agency schemes as responses to the earlier, longer history and as attempts to counteract earlier democratic deficits. And I'll stop there. Thanks.
Thanks so much, Joy. That was a very good synopsis of the paper. And I'm sure there's a lot to discuss after we hear from David and Jonathan. So David's paper is called Racial Box Checking and the Administrative State. And as I said earlier, builds on his recent book. So David, please take it away.
Sure, thanks. So the main theme of my paper is to point out that the standard American racial and ethnic classifications we're all familiar with, both culturally, but also when we check boxes, when we apply for college, request a mortgage, fill out medical paperwork, and so forth, aren't the product of some spontaneous order or just what society decided somehow, but rather an obscure bureaucratic process that, as I describe in my book Classified, amounted to a combination of amateur anthropology and sociology, interest group lobbying, incompetence, inertia, lack of public oversight, and happenstance. And in particular, and I have to admit, I was writing about race and legal history for most of my academic career, and before I wrote my book and researched it, and the article that led to it, I had never heard of this myself. Federal Office Management and Budget enacted a rule in the Federal Register called Statistical Directive Number 15 in 1978. And the idea was to create uniform ethnic and racial classifications, primarily just so that data could be efficiently shared and compared across federal agencies, because different federal agencies were using different classifications and different definitions, and it was hard to compare educational or civil rights or any other data across agencies if no one could agree on who they were collecting data about. So oddly enough, this rule became extremely important over time, but gets almost no attention in the law review literature. I tried to look it up in Westlaw in all the different ways that the directive is referred to, and I found about 34 articles, including 2 of my own, most of them obscure. So this is something that doesn't really get any attention in the law review literature, so I thought it was useful to talk about it some more. So we're pretty much familiar with the relevant classifications: American Indian, Asian, or Pacific Islander, with Pacific Islander, Native Hawaiian later broken off, Black, white, and Hispanic, which is officially the only ethnic rather than racial classification. And I think one thing that most people are surprised by is not only did the government create these classifications, but they actually define them. So there are actually official definitions of what it means to be Black, Hispanic, etc., and they're all mutually inconsistent. They use different criteria, whether it be geography or culture or continent of origin. At the time, this was done not secretly, but you won't find articles in the New York Times at the time about this because no one really was paying attention. Again, these classifications were solely meant for statistic keeping purposes. They warned, the OMB warned in the Federal Register. By the way, they said these are not, they didn't use the word by the way, but they said these are not to be used for eligibility for any government program. They're not meant to be scientific. They're not meant to be anthropological. But those warnings and caveats, not entirely surprisingly in retrospect, were studiously ignored. The result was that the classifications have had a profound effect on American life, especially on how Americans identify themselves and others. So there are certain identities that barely existed in 1977, such as Hispanic and Asian American, that are now mainstream, but there were other identities that were quite common in the 1970s, like Italian American or Chicano, that very few people use anymore. The social influence of government racial classifications is constantly reinforced by the fact that all sorts of studies that come out about American life use this classification scheme. Some of these are just by habit, like pollsters will use them, and there's no one requiring them to do so. But in a lot of cases, if you're a young researcher trying to get your PhD or trying to get tenure, and you want to do research on ethnic, racial, or just general American life, you have little choice but to use these Directive 15 classifications, because the biggest data source are the reports that the Census Bureau does every 10 years, and those are done based on these classifications. For that matter, let's say you want to study education in Florida. Well, you could do it by Hispanic, because all the schools report Hispanic data to the Department of Education. But if you want to do it by breaking down how are Puerto Ricans in Florida doing, or how are Cuban Americans doing, or Mexican Americans, you wouldn't be able to find that easily. You'd have to do your own research, and most young or even not so young academics don't have the resources to make their own databases. The Directive 15 classifications also quickly became affirmative action categories. And whenever you think about affirmative action, or whatever position you take on that, it's kind of interesting that the classifications we use were not meant for that purpose. In fact, again, it was sort of disclaimed, these are not meant to create eligibility for programs. In particular, the classifications are universally used in higher education, and with occasional slight modifications in government contracting for eligibility for minority business enterprises. And this has significant effects on who benefits and who doesn't benefit from the relevant policies. As Professor Milligan suggested, a lot of the programs that we're going to be referencing, or at least alluding to, were originally created primarily to bring African Americans who had suffered through slavery, Jim Crow, and so forth, and were suffering the after effects of that, into the economic mainstream. And that seemed to be a plausible outcome of using these classifications in 1978, when America was still overwhelmingly either white or black, and even the relatively small percentage of Hispanics were generally considered to be white until they were separately classified. But since then, we've had large-scale immigration from Asia, Latin America, Africa, the Caribbean, since the 1970s. And we've also had a significant increase in interracial, interethnic marriage rates. So today, for example, for minority business enterprises, anyone who's classified as anything other than white is eligible. So anyone who's Asian, anyone who's Hispanic, anyone who's Native American, anyone who's black. And the end result is that the vast majority of these minority business enterprises go not to African Americans, not to people who were even in the United States before the Civil Rights, whose families were in the United States before the Civil Rights Movement, but to post-1965 immigrants and their descendants. And I've frankly yet to hear anyone defending the proposition that someone should be able to move here from Buenos Aires, stay here for 5 years, become a citizen, suddenly they get a preference for minority business enterprises. In fact, the best data I could find suggests that less than 20% of the minority business enterprise money at the federal level at least goes to African Americans, and of those, it's not clear, because no one keeps the statistic, how much goes to immigrants and how much is going to the original intended beneficiaries. In education, most beneficiaries of affirmative action preferences for African Americans at elite schools like Ivy League schools are first and second generation immigrants, again, not descendants of American slaves. And this is a direct result of Directive 15 defining Black or African American as someone descended from one of the Black races of Africa. That's the exact definition. And thus it doesn't differentiate people who have had a family history of oppression and discrimination and violence in the United States from those who just arrived from other countries recently. Directive 15 has also had profound, and in my opinion, profoundly negative effects on biomedical research. In the late 1990s, Congress mandated that the FDA and NIH have to recruit enough, whatever that means, people by each category, and also analyze their data by race. Now, the NIH and FDA didn't say what classifications had to be used, but both agencies, for obvious political reasons, did not want to, try to create an expert panel saying, hey, what kind of racial classifications would make sense in the context of biomedical research? So instead, and despite the fact that Directive 15 classifications were explicitly not meant to be scientific, they just adopted those classifications, which means that these crude Directive 15 classifications are now in practice used as pseudoscientific racial categories in biomedical research. And this encourages pernicious racial essentialism in scientific research and medical practice that has no scientific grounding. So just to give some examples of the problems this causes, biomedical researchers are mixing individuals with little genetic commonality, and genes, unlike race, is actually not just socially constructed, but scientifically important, into a single research classification. So for example, if you're a researcher and you have to satisfy the requirement to use Asian American subjects, you could go to Minnesota, to Minneapolis, recruit however many Hmong immigrants and their descendants that you need to satisfy that criteria, and then you're set. Now, this is not going to give you useful information for Asian Indian Americans or Pakistani Americans or Filipinos who really have nothing genetically or sociologically in common with the Hmong, except they have to be classified as Asian American by the government. Indeed, you're not even really going to get useful data for Hmong Americans, because when this data gets reported to the government and in medical journals, it will just say Asian Americans, and you won't have any idea of which group of Asian Americans it was tested on. I suppose you could actually email the author and ask if they'll tell you, but it will not be obvious from the study itself. So given all these points, I don't take the strong position that we should never classify anybody in any context, but I do suggest that it's time to completely overhaul the classifications. The classifications, again, were meant primarily for statistical purposes, to enforce civil rights laws and that sort of thing. It wasn't meant to have all these different societal uses that we've become accustomed to, and therefore they weren't created with that in mind and aren't really well suited for that. So even if you believe in all sorts of remedial or reparative or diversity kind of programs, you have to question, well, why these specific criteria? So we really don't want these classifications as they're being used now to dictate how social science researchers study the American population, how scientific research is undertaken, who's eligible for affirmative action, and so on. So first thing I would do is say, well, do we always need to classify people? I'm not saying you never do, but it's sort of done by rote now. So I would say the government should give a reasonably good justification, maybe even a compelling interest to satisfy the 14th Amendment before it does classify individuals by race. And second, to the extent that the classifications are justified by compelling interest, you actually should be using classifications that kind of are narrowly tailored to actually promote that interest. And in particular, the OMB really needs to recognize that given that the classifications are used for distinct purposes, they need to be tailored for those purposes. So if you're trying to study public health, it might be very different than if you're trying to study the effects of a particular drug on particular people with particular genetic backgrounds, which might also be different than who you might want to be eligible for an affirmative action program, and so forth, and so on. In many cases, it would be useful, for example, to break the broad crude classifications into more meaningful subcategories. And I'd say, this is way too broad a thought to cover in the time I have remaining, but my brief concluding thought, nevertheless, is that in the long run, we should be considering whether we need to have any sort of official racial classification in the United States. And I think that a lot of how you feel about that depends on how optimistic you are or not that the United States could overcome its history of racism and become a country with sort of a non-racial or multiracial identity. I think if you're skeptical of that, you're likely to say, well, since that's never going to happen, or I doubt it's going to happen, we need to create social justice by making sure each group gets its fair share. If you are more optimistic about that, as I think I am, for reasons we could maybe get into in the Q&A, I think that we could imagine a future where your race or ethnic background doesn't have much of an effect on what you could expect from your life prospects. And if that is something that we can aspire to reasonably, we at least want to make sure the government doesn't get in the way. Thank you.
Thank you, David. I don't know, maybe 25 years? I don't know. Would be enough time. Our last speaker, that's very helpful. And I think David's paper is a helpful setup to what Jonathan Berry is going to talk about. And I just realized that Jonathan, actually, the version of the paper I have doesn't actually have a title on it. So maybe Jonathan.
Suggestions welcome.
Oh, okay, good. And but he talks about these issues of how classifications are used in a couple of parts. One, the administrative state created the current racial classification system and now requires it. And racial classification creates momentum towards racial discrimination. And then he has a case study, as I alluded to in the introduction, about the use of these classifications in an apprenticeship program that the Department of Labor is managing. And he, unlike David, says that we should end the use of racial classifications in government programs. So I'll turn it over to you, Jonathan.
All right, thanks so much. It's great to be here with y'all today. I think to take up where the conversation has just left off, I'd like to lay out how it is that the modern day practice of racial classification, starting by and large with the governmental scheme that David has researched so deeply, like educated me personally about it. This is where I learned about this really from his research. My intent is to, what I discuss in further detail in the paper, is to go to show the ways in which these schemes of classification, pretty broadly, maybe not universally, but pretty broadly, have a tendency to encourage race discrimination today in ways that we ought to be really concerned about, and in ways that I think commonly could well be unlawful under modern equal protection doctrine. So the core issue to kind of look forward to the ideal state, or at least better state that David gestured at towards the end, in terms of where we'd like to be headed, I would say at the outset that racial classification and the racial discrimination and dysfunctional or problematic governance that it encourages, it serves only to heighten the salience of race in our society. Now, I agree completely with Joy, and I don't know how any student of history could not. It's too many negatives, but I agree that this country has a very sad history when it comes to race relations, race-based chattel slavery, and race-based segregation, most profoundly, but not exclusively those things, that have left deep scars and that we need to continue to grapple with. The part of the challenge today, and David has already talked about this a little bit, is one of traceability to the modern situation, where we now have. There's no question that some of the disparities that we see continuing to persist along racial lines, are themselves the fruit of some of those race-based policies. It is also the case in many of the cases that those policies ended decades ago, and it's also the case that we now have the confounding and confusing factors of all these inflows of immigration from different parts of the world, as well as rates of intermarriage, such that their family histories start to draw on more threads of American history. I would to talk about it in sort of a transcendent or atemporal dimension for a second. I'd submit that race is an objectively minor attribute of the human person, and foregrounding it unnecessarily diminishes the inherent and equal dignity of every human being, and it leaves our society degraded in the process. Here, I think, is where Justice Harlan's dissent in Plessy versus Ferguson had it just right in a line that I think deserves to be more famous. In respect of civil rights common to all citizens, the Constitution of the United States does not, I think, permit any public authority to know the race of those entitled to be protected in the enjoyment of such rights. I think that's fascinating and a concept I hope to unpack further. So on the genesis of these modern classifications, as I said, I defer completely to David's research. Just one concept I would want to add as a comment is that of legibility. In order to maximize the effect of anti-discrimination mandates, the government needs crisp definitions of race to make it maximally legible and recordable. I get this analogy from James Scott's great book, Seeing Like a State. Look at the example of medieval rulers struggling to tax peasants in villages where, as was common, no one had a true last name. So in that situation, how can you know who is who, let alone how much to tax, A versus B? Like, these guys are both named John. Like, what do I do? So commonly, Middle Ages rulers would force last names upon their subjects. The most recent example of this I'm aware of is the imperial Spanish imposition of Spanish surnames on the Philippines in, I want to say, 1849, I believe. So the power to rule is thus augmented by the power to classify. And I think, understandably, the Civil Rights Revolution wanted classifications too. David has already talked about some of these schemes. One more I would add with my area of focus is the EEO-1 form, a mandatory data collection that requires all mid-sized private employers to submit demographic info, including race, to the EEOC. Then the example that Renée has anticipated, my main one, my old agency, the Department of Labor, recently proposed updating its apprenticeship rules. And this is a proposal that didn't have to enter into racial controversies, but they made their way in regardless. The proposal requires that apprenticeship providers report on the demographic information on every participant, and requires apprenticeship sponsors to submit written plans for the equitable recruitment and retention of apprentices. And I'll come back to that in a moment, because how central these kinds of requirements of classification are. This is in some way reminiscent of what's been going on in corporate HR for quite some time. And a lot of this is from research that Frank Dobbin at Harvard has written about in depth. Especially with the advent of disparate impact liability under Title VII, thanks to the court's decision in Griggs, there was a lot of uncertainty among business leaders about exactly what their anti-discrimination legal obligations were. And to make matters worse, from a clarity perspective, EEOC did not have, or certainly did not clearly have, substantive rulemaking authority in this space. So that ended up empowering the HR profession to develop series of best practices that ended up being used as aids to compliance or as affirmative showings of good faith. Two practices that bear special mention here are HR's creation of offices to deal with EEO, and second, HR began collecting data on progress towards integration and the reduction of bias, and holding managers individually accountable for driving diversification. By using racial classification data as a key part of performance evaluation, we started seeing more business decision makers naturally making decisions on the basis of race and internalizing a race-conscious attitude. Our federal public administrative agencies contain a similar infrastructure revolving around racial classification. I'll focus on data collection and research, such as the Chief Evaluation Office and the evidence-based policymaking space, which was a component of the office I used to oversee at DOL. These offices and the research community that they interact with tend to place a primary focus on collecting race-classified data and using it to drive policymakers to make decisions with changing racial balance at the front of mind. And then, in turn, the government is ensuring that race-classified data is collected, published, and used to hector both policymakers and private parties to change outcomes, to achieve a different racial balance. So how does this happen with, to take this example of classification inserted by DOL, imagine what happens when they collect this data. So first, that evaluation office is going to publish a report documenting underperformance or underattainment among certain minority groups, among apprenticeships. DOL maybe organizes a conference for operators of apprenticeships and gets consultants to lecture on the need to increase representation. DOL gets a contractor to review apprenticeship plan submissions, and the contractor suggests rewrites to those submissions that ensure an increase in specific races' participation or passage. It's tough to see how this does not add up to an encouragement of discrimination on the basis of race, which is, again, the thing alongside actual requirement of discrimination that runs afoul of modern equal protection doctrine. I think there are, as I've implied, I think there's very serious legal issues there. It is entirely within the scope of the doctrine to allow classification when necessary to remedy past discrimination, and sort of the scope of that remedial exception to the general bar on race-conscious state action is certainly worth a lot of discussion. Though I think it is subject to the traceability issue that has come up in this conversation. And there may be places where classification does not encourage race discrimination. I think David has identified some candidates there. But the broad-based practice of classification should almost always be unconstitutional in my view. So I've gone on a little long. I'll end with one more observation from Justice Harlan in his Plessy dissent, where he advises that we ought to be obliterating the race line from our systems of governments, national and state, and placing our free institutions upon the broad and sure foundation of the equality of all men before the law. All right, thanks.
Thanks very much, Jonathan. So this is the point where I want to go back to Joy in the first instance, and then David, to see if you would like to augment what you said or respond to anything that the other speakers have said, react to it in any way. I mean, I think some other countries, have taken this approach that Jonathan has just articulating, France being a notable one. And it's not clear to me that's worked out much better for them than it has for us. And so I guess the question is, so there's a lot to discuss here, because if we take seriously this question that, there was at least a problem in the past, which maybe has current effects, figuring out what to do about that today seems to be the challenge of our time. So anyway, I'll be quiet and see if Joy wants to jump in here and comment on anything.
Sure. So thanks. It was really interesting to listen to both of you and to read your essays as well, which fed a lot of thought for me. I mean, I think what I've found interesting in these conversations for a while is how much really difficult empirical questions and priors about empirical questions sit under opposing policy positions. So I guess in that light, kind of in light of that background thought, I wanted to raise a couple of things for each of you. If I'll try to go quick, if you'll allow it, Renee.
Oh yeah, of course.
So, I mean, for David, I learned a lot also from this and from your book. I guess one thing, you do allude to the social influence of government classifications. And I find it really hard, like empirically, how do we know, especially tracing the longer history, which I know you point out in your book, what we know about the longer history of government racial classification, which we had a segregated military, we had segregated workforces and federal agencies. We could trace a lot further into state and local practices. And in just kind of the social reality of race, how would we even untease the way government, I see what you're saying in sort of the biomedical research or something. I can see how that traces, but kind of if we want to come to broad conclusions about the impact and net harm or benefit of racial classifications, I find it hard to deconstruct from underlying kind of everyday racism and social realities of race in our society from like how we would isolate, the OMB directive and its continuing life. And somewhat relatedly, I think I found really interesting. I don't think you mentioned this as much in your presentation, but you brought up the example of biracial people and immigrants, African immigrants, people of African descent immigrants, and kind of how they mix into the category of African American. And I'm sympathetic, again, rooted in history, to the idea that we might want to distinguish in some ways between like sort of people's history of being here and being subjected to US-based discrimination. But I also wonder how we would, given that we had a one-drop rule, say for the biracial people, that we have kind of the legacy of hypo-descent mandates for who was subjected to slavery and Jim Crow, how would we distinguish like why biracial people don't experience kind of the reality of race in relatively equivalent ways to any other Black identified person? And the immigrants are kind of like, well, if we start parsing like Europe, you did slavery in the Caribbean. So folks from the Caribbean will think you're responsible for any inequities they've suffered. And then maybe when they get here, if they're responsible, where it's only present day discrimination, it just seems a bit hard empirically to kind of dissect all that. But I'm very sympathetic to your underlying point, which is maybe the current classifications are really coarse and and could be much improved. Jonathan, I just come back to kind of, I think we're more starkly different in where we're coming out on racial classifications and their utility in the present. I guess, it struck me when you said that your transcendent atemporal take on race, and now I'm paraphrasing, I didn't write this part down, so correct me, but I wrote down something like race is a relatively minor aspect of human experience and identity. But I wonder if that's not true for some people. Do you know, that's very difficult to adjudicate in some permanent lasting truth sense. And so I wonder if that's just kind of an empirical disagreement about what race is and how it works into people's experience of the world. And if we should be kind of open to the possibility that there are multiple experiences of that. I've been in the Labor Department archives a lot lately, actually. So I guess I would just ask you.
Lucky you.
Right. There's such a long history of apprenticeships being whites only. And the Labor Department didn't do anything about that for decades. Should that matter for how we think about whether we should measure what's happening in apprenticeships now? I'll stop. Sorry for being long.
Oh, no, that's all right. Can I just add one thing, maybe? And Joy's comment alluded to this, and then I'll let Jonathan and David speak. But my experience is, my parents were married before Loving v. Virginia was decided. They're an interracial couple, right? But the world has always taken one look at me and said, she is Black, and that's how we're going to categorize her. And so I guess the question is, does that social construct matter in these conversations? And I think Joy was kind of alluding to that a little bit in some of what she was saying. And I guess that's really another issue. It's not just technically, can we draw the line from what happened in the past to today, but how people are experienced in the world today is another aspect of this conversation. So anyway, I'll be quiet now too.
lot to unpack there, but let me try to do it relatively briefly. As far as the issues of hypo-descent and immigrants, I think these are all really tough issues. And I mean, I certainly wouldn't say, well, since Barack Obama was both a child of an immigrant, or not even really an immigrant, a temporary resident of the U.S., and a white woman, that his success had no bearing on African Americans, right? So there's obviously a lot to unpack there. But what I would say is that it's the sort of thing that it wasn't like, well, a lot of people sat around and discussed it and ironed out all the different possibilities and how we want to handle this. It just sort of happened by like, bureaucratic fiat. In fact, there was a time in the late 80s when African and Caribbean immigration were picking up, and someone, I forget who, wrote to the OMB and said, we're not really sure how to classify immigrants from Africa. Are they Black, African American, or should they be a separate immigrant category? And OMB just said, okay, put them in the same category. But it wasn't like there was a public debate or roundtables and research. It was just really done in that sense. And I think that in the context of universities, there really, in affirmative action, for example, there really weren't people who at any point sat down and said, hey, our class is becoming of African American students is increasingly first and second generation immigrants. Is that consistent with our vision of what diversity looks like? Is it not? Why? Again, it was just sort of, well, that's what the Department of Education says they're Black, and they look Black, so we'll go with that. And by the way, it's sort of ironic and to me at least somewhat troubling that the criteria for being Black or / African American in federal law is descent from any of the Black races of Africa, which is a one-drop rule essentially, and it's sort of been now codified into federal law. It could have been something like that, plus affiliation with African American culture or something, but they chose really to just incorporate the rule. And in fairness to them, again, it wasn't like no one was really thinking about that deeply. I mean, one of the reasons these problems weren't at the forefront of people's minds is, again, over 80% of the population was white at the time. About 12% was African American. All the other groups were kind of small. Hispanics were the only other relatively large group, but they weren't really a group yet. They were mostly, there were Mexican Americans and Cuban Americans. There wasn't the pan-national identity, and they're mostly considered white. And because we had this history of hypo descent, I think everyone at the time kind of thought, well, we all know who's Black and who's white. So it's not really an issue. And the idea there'd be all these immigrants and a lot more interracial marriage just wasn't something on the horizon. So again, I'm not saying what the correct answer necessarily is about how and in what context to treat subgroups of African Americans differently. I'm just saying that it hasn't really been addressed by the powers that be. It just happened by inertia. As for the social reality of race, I mean, there is one way that you can look up some of this stuff and see the results is just to go back on Google Ngram or other research databases and see where people refer to as Hispanic in 1970. When did that start to become a phrase people used? When did people start to use Latino? When did Asian Americans start to come into play? Interestingly enough, Hispanic, Latino wasn't really used much until it became a federal category, but people at the grassroots level have come to accept it. The survey data shows if you ask people who we call Latino or Hispanic, do you consider yourselves that? They will mostly say, I mostly think of myself either as just American or as Cuban American or Mexican American, but I also am fine if you call me Hispanic or Latino. On the other hand, for Asian Americans, where they really, really don't have anything in common except they don't even have the linguistic commonality, most Asian Americans will say, I don't want to be called Asian American at all. It's not part of my identity. Some do, like 40%, but 60% say don't call me that at all. So there's an example where so far, at least, the classification has not been as influential at the grassroots as you might expect, although it is very influential in our sort of academic circles. So, but I didn't get into this in the paper, but it's in the book. There are all sorts of twists and turns in the history. Everyone knew we were going to have a Black classification and a white classification, but who else would be in there and in what context and how it would be defined was really a matter of happenstance. You could easily imagine twists and turns where we would have had a Chicano classification and no other Hispanic classification, where Asian Indians would have been white rather than Asian, which almost happened, and where there would have been certain white subgroups like Eastern European Catholic or whatever, and that didn't happen. So it's definitely had some effect, but as maybe I'll get to comment on your paper. Counterfactual history is always kind of tough.
Jonathan.
Yeah, just a couple of brief follow-ups, because I did get the benefit of batting cleanup. One is, so Joy, I think you put your finger on really the question of priors here. I didn't quite, and I know I'm going. I kind of on the spot came up with the descriptors of, what did I say, transcendent or atemporal as my modifiers. But what I didn't mean to say, and didn't, it was not my intent, I don't think I did say, was that I think today, and that Renée alluded to this as well, that today the social reality of race is a minor thing. I don't believe that. I think that would blinker today's reality. I would say I wouldn't characterize it as much of an like an empirical disagreement or empirical question, so much as more like philosophical or metaphysical. The analogy I'll use, and enough decades ago, this would not have been a contentious analogy, but I can't think of a better one, so I'm going to use this one right now. Is the analogy between race and sex, and specifically that. So I would phrase it something along the lines of the objective attributes of race are relatively minor, but there is a thick sort of constructed layer on top of that. And I would make a difference between that and sex, where I do believe that sexual differentiation, male and female, is a major constitutive aspect of any human person, anywhere, any place, any time in history. And then on top of that, there is also a thick social constructed layer as well. Like maybe a better analogy would be, that's slightly less contentious these days, would be language, which has a natural foundation, but atop which there is a thick social construct. Then also just briefly on the question of the point about DOL and apprenticeships. Yeah, I'm well aware that there is a you go back far enough simply into the 20th century, and you've got a lot of race discrimination baked into a lot of these things. I don't know. I'm just not aware of the extent to which U.S. DOL was, call it affirmatively, part of the problem, as opposed to having failed to intervene. I don't know. Probably some of both, I would surmise. The challenge though today is working through the I think I share your intuition that history continues to have some relevance to how we think about the policy questions today. The hard part for me is figuring out how much. And I certainly, my impression, I've not yet studied this. I plan to look on this actually in the next couple of weeks. My impression is that the disparities today in this regard are far smaller, and certainly within the margin where it begins to raise much more substantial questions about whether the game is worth the candle to try to affirmatively intervene now on the basis of race.
So somebody mentioned the New York Times earlier, because on that point, the New York Times today has this article about a new study, which I have not read the study, of the reemergence of poverty after the expiration of some of the pandemic era child tax credits and things like that, which are have a heavy disparately racial impact. So I just it's sort of this conversation is one that can go on and on and on, because we have new interventions and then things happen, and we have to examine kind of what the influences have been. But I'm going to say one other thing, and then I'll ask a moderator type question, which is one thing about this conversation about how historically have people of other races, not blacks, been viewed, in the United States. And there have been, cases but they just don't get as much visibility as the ones involving Black Americans have gotten in the legal literature, because before Loving, there was Perez against Sharp in California about could California prohibit, someone of Mexican descent, I think it was, for marrying a white person. And it was, a California state case. There were, cases in the Jim Crow states about, were Asian Americans, were they white or were they colored, quote unquote colored, and which school did they have to attend? And so I think, and then there's a jury case, Hernandez v. Texas, I think is the name of it, which, deals with the same issue about, service on a jury. So these are cases from like the 40s, maybe, or, around that era. So I think that, these other groups too have had this kind of issue of the world, the society, governments trying to figure out where do they fit, and in a society that really has been organized by whites and then everybody else. So I think that, I don't know, it's one thing worth exploring as we think about the history of these things. But I guess the moderator type question I'll ask is that, David makes, this really powerful argument about the imprecision and inaccuracy of racial categories, and that, to some extent they may not be helpful depending on what the program is for which they're used, if they're used at all. And then Jonathan argues that any race should be unlawful because it's creating more harm than good. I'm grossly oversimplifying what you both said.
I appreciate that, but go on.
Yes, okay. So I guess the question is, what is your response to Joy's argument that the current structure and the content of the programs are a result of democratic disenfranchisement carried out on the basis of race and class? Do you agree that that's a problem? And then if that's a problem, does it rise to the level of intentional discrimination that could justify a remedy under, how we now see current equal protection doctrine, or is that not enough?
So I really appreciated Joy's paper because it reminded me of my first book, Only One Place of Redress, African Americans' Labor Regulations of the Course from Reconstruction to the New Deal, where I talked about how a lot of the labor rules that are typically celebrated in academia were actually created at a time when Black people couldn't vote, and not surprisingly, or largely couldn't vote, and not surprisingly, either didn't take the interests of Black Americans into account, or were affirmatively intended to harm them. And so it was sort of attacking the godlike figure of FDR implicitly in the New Deal. So it did not go over well with my in some circles, especially because which could reach my second point, partly because I said, well, they would have been better off if there wasn't regulation at all. Everyone said, well, they would have been better off with better regulation. And of course, that's true, but how do you get better regulation if the people can't vote? But that raises an additional point, which I wanted to raise about Joy's paper, which is that, of course, in some ways, African Americans would have been better off if they could have voted, and certainly at the state and local level, if they were 52% of the population of Mississippi, they would have been a lot better off being able to vote, being 52% of the voters than being like 2% of the voters. However, I think at the national level, things get more complicated. Partly that the federalism of the United States wasn't simply, there was deep-rooted support for federalism beyond any racial implications, but also I think it's my colleague Ilya Soman once talked about trying to write an article, a more theoretical article, about when will national politics be good for minority groups. And we never did that. But it did occur to me that it's not always the case that at a national level, if a group that is concentrated, especially if it's concentrated locally, will do better politically as they get more power. Sometimes there's a reaction against that group getting power, and other groups that might have been in conflict will then unite against the less popular, the group that's overall less popular. And I don't know, I think comparative study would be interesting in this regard. It occurs to me, for example, I'm not an expert on this, but I know that Jews could vote in Poland before World War II, and they were like 10% of the population of Poland. They had 10% of the seats or so in the parliament, the Sejm, I think I don't know how to pronounce that, Sejm, and they still managed to pass laws restricting, Jews to being X% of the universities and all that, and basically all the other parties were against the Jewish parties. So one has to just keep in mind. Of course, one could imagine a different past and a better past without African-American disenfranchisement, and certainly the Voting Rights Act was probably the most important piece of civil rights legislation, which even though it gets less attention than some of the others. But it's not always a happy story. A lot depends on the political structure of whether minority groups are inherently able to influence the process or not, and you have to look at how it would work out if there had been 50 black members of Congress in 1920, would that have how much better would things have done? Certain things would have been different. Some things would have certainly been better. Not clear for everything. Now, the related point, which goes, I am a libertarianish guy politically, so I tend to be skeptical of politics and government. And it raises the question, even if we can assert that, yes, there are historical injustices that still manifest themselves in current times, and that if we were God, king, dictator, and could wave a wand to overcome them through certain policies, would we do so? But then there's the other question of, as a matter of practical politics, what is going to work? And this gets to issues of classification, also to long-standing debates among progressive activists. Do we want targeted social policies that specifically help African Americans or other groups, or do we want broad social democratic policies and help everybody, with the argument on the second side that obviously it's going to be an easier sell to the population in general if it's benefiting everyone, even if it disproportionately benefits groups that are less well off. And also, I think, with regard to classification in particular, there are inherent dangers in the government setting aside certain groups, saying, based on this identity, you get this and you get that, because while we'd like to think that people will be enlightened and say, oh, we're only doing that to help make up for past things, it doesn't generally work that way. In-groups tend to support in-groups and dislike out-groups. And, the one example, I'm not an expert on this either, but one thing I read once, which really disturbed me and made me wonder about how plausible it is to advocate for reparative policies in the United States or anywhere really, based on race or ethnicity in particular, is that an author asserted, and again, I'm not an expert to know if this is true, but when Konrad Adenauer offered reparations based on property loss and whatnot to Holocaust survivors, this was widely opposed by the German public. And this isn't like 150 years later, like right after the Holocaust, when literally the government had murdered 6 million people, and we're only giving a very partial compensation for property damage. Even then, people are like, oh, well, why should we give money to them? So that's just the way people work, and I'm not sure that politically speaking, it's plausible in the long term to say, hey, even if we identify these very specific harms that have done and continue, that the way to sell ameliorative policies is to say we're helping that specific group instead. We're helping fellow Americans, which will include this group maybe disproportionately, but it's because they're fellow Americans, not because they're members of the group. Make them part of the in-group rather than continue to be out-group.
Yeah, so this makes it even more amazing that there was the reparations package for the Japanese Americans who were interned in World War II, right? That was a big slog, but it was obviously not very significant individually to each individual person, but it did happen. Jonathan.
So David has literally written an entire book about this, so I won't add too much in this ballpark, but I think I would add simply that for reasons many of the kind that David gave, and a potentially or certainly unjust situation, however many years ago in the past, then has a variety of all kinds of things happen historically that shape the present environment, both as a matter of public policy and socioeconomics, that make it be the case that, like, it's today, it's possible that certain things wouldn't be so different. There's also this also gets into, of course, the very difficult empirical questions about causation, like why does this lamentable disparity of type X or Y exist, and in the meantime, this had allocating benefits and burdens today on the basis of race, among other things, has the tendency to distract attention from targeting like the direct things today that are that continue to be the issue, like targeting a sort of aid on the basis of socioeconomic status, availability of social capital, whatever it is. Not a lot to add beyond what's already been said.
Joy, did you want to add anything there?
I always have a couple of thoughts.
Yeah.
Do we have time, Renee?
Yeah, we do. We have a couple more minutes.
Yeah, I mean, I was going back. Well, a couple of things. I tend to be a class and race person. Like, I think both matter a lot. And so I guess I'll just say, when we think back to what Justice Harlan said in Plessy or the civil rights cases or any of these dissents. I mourn that moment, because obviously we did not take that path. And so part of my thought process is that we really kind of lost some opportunities for building a more egalitarian society that make the attempt to do it through colorblindness now much more difficult. And again, like my essay in some ways is mourning lost chances for a more egalitarian social policy, which, a lot of poor whites weren't voting in the South. I mean, these figures we see on who was voting, it's kind of mind-boggling how little of the population was voting. So I guess I see in some ways the essay I wrote for this is about kind of the real class ramifications of disenfranchising so many people and blocking off those kinds of more general race-neutral policies. But I don't think that, but for me, the fact that we didn't do it earlier has real important impacts in how I think the world has been shaped since then. And so, David, you said something about, there's the people who are optimists about like race will wash out over time, will become more egalitarian, and the pessimists, which, might be more like this, like maybe a simplified version of CRT, racial division is permanent in U.S. society, hence we need ongoing kind of race-based programs. But I think there's like a middle ground. I tend to be pretty optimistic about government policy, hence I'm not a libertarian. And so I think there's room to think that one way through as an empirical matter is to really seek, to create a more egalitarian foundation for our polity along multiple axes in the hope that we get to that place that you signaled in the future. And that's where, Jonathan, I think empirically, although I see your philosophical point about, race should be irrelevant to our lives, I guess I feel like, when Chief Justice Roberts says the way to stop discriminating on the basis of race is to stop, discriminating
on the basis of race.
I feel like beneath that is an empirical presupposition. I tend to think that there must be a claim that over the long haul, racial division, if left alone, will tend to wash out. But I guess I just don't think, like, empirically, like, the data on social mobility, intergenerational shift in socioeconomic class, the social reality of race, like, I just don't tend to think that that'll happen. to me, it's an empirical point. I don't know. Maybe the kind of countervailing philosophical value could be so strong for some that empirical question that's hard to know. Matt,
I think one interesting thing that's going on right now is these sort of pilot studies and experiments around the country on guaranteed income. Because they're really taking it's sort of David's point. They're taking this socioeconomic fact and applying a broad remedy across the board, not based on race, just economic status entirely. But it has a disproportionate effect on certain racial groups. And I think that, all of these programs are being studied quite rigorously by academics. Are people, sitting at home watching TV or going to the casino parlors, or are they actually really doing ordinary things with the money that we all would do, buy their kids shoes, pay the copay to go to the doctor, whatever it is. And I think that because, my whole position about some of this is that, money doesn't solve all the problems, but it does take care of quite a few of them. And that leveling that playing field at some level, or at least taking a lot of the, significant pressure off of people's lives, might be a way out of this, but it's going to be a very long time before we know the answer to the effect of that kind of intervention, on the social mobility question, because that's a multi-generational thing.
Yeah, that if I can jump in really quick. I've been for a few years now, really stemming back to my time at the Labor Department. I've become a more vocal advocate of, as a political conservative, the need for conservatives to engage more seriously with the concerns of the working class, in particular, and the thing about targeting aid and certain kinds of income support or certain kinds of child tax credit that Renée had mentioned are certainly things that I can and have gotten behind. I do think that some kind of connection to work is important, and I'm not convinced it should be unrestricted. But getting a little far afield, the thing that's relevant for this conversation is that we can indeed have a certain amount of, call it kind of class-targeted aid, and which recognizes, among other things, that class or socioeconomic status is mutable, is changeable, and indeed these policy interventions are designed to change or ameliorate the situation of having kind of low social capital or something like that. Those are mutable. Those attributes are mutable in a way that at least the objective component of race is not. And when you do race and class, what you can end up in is the odd situation that, like David has alluded to, where you have a lot of members of a minority race who are in upper classes, who end up being the disproportionate beneficiaries of, say, elite university affirmative action. That's at minimum strange, and at maximum very far afield from the remedial rationales or the historical sort of grounded rationale, Joy, that you've put forward.
Just if I could just elaborate, this is a little bit far afield from my paper, but it's really been bothering me. So and it's opportunity to say it once again publicly.
Airing of grievances.
Yes, it's a Festivus airing of grievances. When just out of curiosity, when the SFFA litigation was going forward, and since it's at least tangentially related, more than tangentially related to the work I was doing, I was just curious to what extent I could easily find any evidence that the elite universities in question were trying to increase the pool of qualified applicants who may have not had life opportunities but would become capable. I'm thinking, Harvard's in Cambridge and Yale's in New Haven and Emory's in Atlanta and WashU's in St. Louis and Baltimore, Johns Hopkins in Baltimore and so forth. They have wonderful opportunities to, with the help of their faculty and the massive resources they have, do various kinds of social experimentations with education, start their own charter schools, have after-school programs, have summer programs. And there is very, very little of that. I mean, precious, precious little. And it's kind of outrageous, right? That all these universities were portraying themselves as vanguards of social justice because they were taking, 60 kids of a certain group rather than 35, whatever it would have been. But they have all these kids living right there who could benefit from, from the sort of things that universities would be really good at doing, in theory at least. And they don't seem to have done that. And I found, and I'm hoping, regardless of how you feel about the SFA decisions, I'm hoping, among other things, that this might light a fire under some of these folks to look into that.
Yeah, I guess, there's, the soft evidence and the hard evidence. I probably know far too much about the Harvard situation that is worth going into in this venue. But I think that, in terms of, like, what are the official programs? What are all the informal tools that we all use to kind of expand the reach of our programs? I think that, some of the universities were doing a lot of those things. And it's a question of, maybe not running a charter school or whatever it is, but doing some of those things. So I definitely agree that they could all do more, but I'm not sure, and are they really the best people? Because, just because Harvard is ostensibly good at higher education doesn't make it really expert at elementary and secondary. I mean, it does have an education school, but it's a different kind of thing than actually running a school for people of a different age group. So actually, I don't know if we have any questions from the audience, and if we do, we should probably get to them.
Thanks, Renee. I've got a couple, and I'll start with one for the whole group. It says, David and Jonathan highlighted many of the practical difficulties of categorizing people by race. Will technological innovations make these issues easier to resolve or harder? Thinking specifically of technology for analyzing people's DNA or ancestry and artificial intelligence.
Well, there has actually been one case so far right along these lines. There was a guy in Washington State who applied, who grew up as white. Actually, I've spoken to him. It turns out his father was a refugee from Nazi Germany. Here's a whole story. But anyway, he was white, and he found that he had some colleagues in the business world who were checking off Native American based on, at best, vague and sometimes fraudulent Native American ancestry. He sort of got mad. So he decided to do a DNA test. And the DNA test, at least allegedly, I haven't seen it, said that he was 5% of African descent and 4% Native American, maybe vice versa. He decided to check off those boxes. So he applied to be a minority business enterprise contractor, both for federal and state purposes. The state of Washington approved him for state purposes, but a different examiner said, no, we want more evidence. He gave him the evidence. They said, no, you're not socially, culturally African American. So for federal purposes, you can stay black for state purposes, but not for federal purposes. And he went to the Department of Transportation, and they upheld that ruling. And the Ninth Circuit then had a very interesting opportunity to talk about the relation, what it means to be black or African American under the rules. And if you take the rules literally, if you believe the DNA test, anyone who is descended from one of the black races of Africa, he would have qualified. And they would have either had to endorse the plain meaning of the rule or explain that even though it says that, it's not what it really means, or say, we don't believe your DNA test, something. Instead, they just punted and just said, we're just going to defer. But my point is that this sort of thing is going to add an additional twist to the difficulties of classification, because we already have people who have, like Elizabeth Warren, who have vague family stories of ancestry. We have people who have legitimate, I have one great-great-grandfather who was from Mexico, and these marginal cases are already problematic. And now we're going to also have people who, if their identity is challenged, are going to say, well, I did my test with 23andMe, and 23andMe says that I'm whatever. And of course, I shouldn't say of course, but the difficulty is that the classifications themselves as defined tend to have relatively crude definitions that say, like, descent from one of the black races of Africa, of Spanish culture or origin. So they seem to be just, if you have descent, it's enough. But in practice, in the real world, the fact that you have, let's say, a enslaved ancestor from Africa from 1780 who then married a white woman and became, and their descendants all became white, you're not really African American from like the kind of point of view of why we have these things to begin with. But this is a pending issue that someone's going to have to address. Actually, there are some cases along these lines, especially with Hispanic identity at the state and administrative level, and courts are basically, and administrative agencies are basically split. Some say it says ancestry, you have the ancestry, or origin, you have the origin, you qualify, and others say you, like, this is actually a little bit offensive, but one case involving someone who was of Spanish origin, Spanish grandparents, it said you don't look Hispanic, you don't speak Spanish, you don't have a Hispanic last name, you're therefore not subject to discrimination based on being Hispanic, therefore it wasn't meant for you. As the you don't look Hispanic, that was Hispanics can look like anything. They're a multiracial group. But anyway, so that is something that I think will be coming up more in the future, but we don't really have a good resolution now.
I mean, another issue with all of that is, do motives matter, right? Is it, people just trying to game the system because they see an opportunity, or I'll sort of see if I can find something to take advantage of the opportunity, or does it not matter?
Right. I mean, the Rachel Dolezal case is very interesting in that regard. If you remember,
Yes.
Rachel Dolezal, she was
Yes.
a woman of complete European ancestry. She had several adopted Black siblings, and for whatever reason, she decided she wanted to adopt a Black identity, but she really lived it. I mean, she wasn't just trying to take advantage of some program or not, but it became embarrassing when it turned out that she had portrayed herself as a Black woman and sort of at least suggested, if not said, she has African-American ancestry, and she didn't, and she was fired from her job, and I think she's had some further misadventures since then. But be that as it may, if we believe race is a social construct, and she was living a life as an African American and was doing it sincerely and not merely checking a box for a program, can we say in some objective way that you're not?
Does anyone else want to weigh in on that one? I've got one more I think we have time for.
Why don't we go to that other question?
This one's actually for you, Renee, if you'll take a question as the moderator.
Oh, sure.
It says, as an expert on administrative law, what do you think are the most underrated aspects of racial equity in modern administration? And what parts of these debates do you think are getting less attention than they should so far?
That's a really interesting question. So I have a whole article that I've written about some of this. But I do think that, sort of going back to something David said about, should these programs be kind of universal, or should they just be, sort of specifically targeted at particular groups? And I think if we think about, programs like the Medicare program, for example, which is not targeted at any group, it's not even targeted on the basis of income, although some means-tested things are starting to creep their way into the Medicare program. But it's probably one of the most popular and publicly supported programs, if you were to ask all Americans. And so I think that that's a significant, something to look at as kind of a model. I think, but I do think that, some of these other means-tested programs, and, we can have a further debate about this, about, how limited the eligibility has been, I think the Affordable Care Act has been, a really great, the Medicaid expansion has been really great at expanding health insurance. I mean, that's not a project that's done by any means, but I think the idea there was to really try to say that just being low income was enough. And you didn't have to have, dependent children. You didn't have to be profoundly disabled or, not have the ability to work. That, that maybe, we should try to lift the floor so that people could, have access to decent health care just because they were merely poor. So I think, I'm not sure I'm quite answering the thrust of that question, but I'm just trying to, point out that there are things that, we've been trying to tweak some of these programs to, to try to, perhaps advance social mobility, or at least, change the way people live their lives, right now.
Well, great. That was great, Renee. Thank you very much. Thanks to you and all of our speakers. I know we've gone a moment long, but that's not a bad thing. Does anybody have any sort of closing thoughts they'd like to add before we wind this down? I see Joy shaking her head politely. No, John.
Just glad to be here, Adam. This was great. Thank you.
This was really great. Thank you. I really liked having the opportunity to read the papers and to hear you explain them.
Well, in that case, I would love to let that just be the final word. So thanks again to our moderator, our authors, the audience, and all those who submitted questions. And also, again, thanks to the Georgetown Journal of Law and Public Policy, which will be publishing these papers and the other papers. And speaking of that, tomorrow is the second installment in this webinar and podcast series. The authors joining us tomorrow are Ming Chen, Jesse Merriam, and Bijal Shah, and their conversation will be moderated by Kamel Foster. Just one last thing before we go. My guess is if you're watching this live stream or listening to this podcast, you already know about the Gray Center's emails. If not, though, please do go to our website and sign up for our newsletter to learn about more conversations like this. I've said a few times, this is all in conjunction with a symposium at the Georgetown Journal of Law and Public Policy. The Gray Center has been involved with a lot of symposia in the last couple of years. We're very proud to partner with law journals on this. And so I can't help but advertise a couple of them. We'll soon have special symposia issues coming out with the George Mason Law Review, which is publishing our symposium on the future of Chevron deference. Needless to say, it's something that's being debated a lot too. And then the Journal of Law, Economics, Policy has a symposium issue coming out on the future of financial regulation. Lots of great papers by Kate Judge, John Macy, John Cochran, our colleague here at Scalia Law, Todd Sawicki, and many others. So please keep an eye out for that. And above all, please keep an eye out for tomorrow's webinar and the next podcast episode. And with that, thanks again, everybody. We'll just call this a wrap.